of the page. For both CFP and CTFA, and this session has been approved for 1 hour of CE for both CFP and CTFA. For CTFA, it is under FID, Fiduciary. This year, we're also happy to be able to provide CE for members of FIRMA, the Fiduciary and Investment Risk Management Association, and those members can get 1 hour CE also by filling out the form. So if you want to get CE, just go to the website and fill out the form according to directions and send it back in. You will notice that you have the ability to ask questions along the way by typing them in. If you do have a question, please do ask it. If it is important at the time, I will stop and ask Alex. If not, we will bring it up at the end. So we will have questions at the end if there are any questions. But if you want to, please do reach out. I believe this is our 11th session for this year, and we've given out probably close to 1,000 hours, maybe more, of free CE already this year. As in past years, we will be taking a vacation break during the months of July and August, but we'll be back with more sessions after Labor Day. So I hope everyone has a great summer, and you check back in mid-August on our website under Education to see what we have lined up for the fall sessions. Today, I am happy to have Alex Ryan with us. Alex is of Counsel at Groom Law Group, an employee benefits law firm in Washington, D.C. He represents ERISA plan sponsors, administrators, trustees, and various financial service providers in a variety of matters involving the administration of employee benefit plans, with a particular focus on issues related to investment of plan funds. Alex has represented clients in matters before and involving the federal courts, the Securities and Exchange Commission, and the Department of Labor. Alex was here back in the late winter, in February actually, talking about the proposed regulations, and I thought it made sense to have him back to talk about the actual regulations as they have been written. So we appreciate having you here, Alex, and look forward to your session. Thanks.
Thanks very much, Mike, and good day to all. It's nice to be speaking with you at the outset. We did this several months ago, and at that point we were talking in terms of hypotheticals, in terms of what could be, at the time, as some of you may recall, regulatory package was still in its proposal phase, so there was a lot of speculation about we now have a final specific definition of the word fiduciary, including in the case of providing investment advice for a fee. And it's very important to remember that ERISA fiduciary status triggers several things. It requires that a standard of care be followed in providing advice to plans, to ERISA plans. It also brings with it the various prohibited transaction rules that ERISA spells out in Section 406. Importantly, and this becomes an important distinction as we go, ERISA plans are covered, obviously, under ERISA. IRAs, however, are not subject to ERISA's regulatory regime. They are part of the prohibited transaction provisions of the code, however. And as we will see, the Department's regulatory initiative increasingly brings IRAs into the regulatory tent. The final rule, as I mentioned at the top, came out on April the 6th of this year, so it's not quite 3 months old at this point. And of course, it redefines what it means to be an investment advice fiduciary to a plan or to an IRA for purposes of triggering fiduciary status. And as I mentioned, triggering fiduciary status brings with it the standard of care, brings with it those prohibited transaction rules. So there's a lot riding on that status. There's also, as I mentioned, the best interest contract exemption, which many folks refer to in shorthand form as the BIC exemption, though it's not a razor or a pen. But this is a sweeping new class exemption that is designed, at least nominally, to allow financial services providers to continue to receive the types of compensation that they have traditionally received in providing services to plans and to IRAs. But as we'll discuss in a few moments, there are a number of procedural and substantive trappings that go along with it that come to the fore in looking at that exemption. As I mentioned, there is also the brand new class exemption for transactions involving principal transactions, so purchases or sales out of the provider's own inventory or from a plan for the provider's own inventory. And there's also a set of discrete surgical amendments to existing prohibited transaction class exemptions that are meant to dovetail with the new rule itself, and we will discuss those later in the presentation. We do expect to get guidance from the Labor Department down the road, as we will discuss, and as you've probably already seen, although the rule and the preamble and the various pieces of this run to hundreds of pages, there are yet many questions left to be answered, many gray areas, many things that we simply don't know, and we are awaiting further guidance from the Labor Department as we go forward. In terms of the timing of all of this, you're aware probably that the effective date is next April, April 10th, 2017. That's for the definition of fiduciary itself. That's for certain pieces of the package. However, the BIC exemption, the big sort of exemption that's at the heart of this regulation, this package, really goes into effect on January 1, 2018. So those are the two dates to keep in mind: April 10, 2017, and January 1, 2018. Seems like a long time from now, but as we'll discuss, there are a lot of things to do, a lot of things to get ready for. So we think that time will pass quickly. Just to kind of distill this down into some key takeaways here, quite obviously, one of the things that this new package does is really expand the universe of who is now a fiduciary for purposes of providing investment advice to plans and to IRAs. And so providers that yesterday thought that they were not fiduciaries by virtue of the types of advice they are giving are finding that today they are. And so that means that there is an expanded exposure to prohibited transaction concerns, which the department has tried to address among other ways through the new BIC exemption. We discussed in the proposal phase of this rule the fact that IRA rollovers are a key piece of this initiative. IRAs have increasingly become a substantial, in fact, the largest space for retirement assets in the retirement services arena, and they have largely been unregulated to date. As we discussed, ERISA does not govern IRAs per se. The code does have a set of prohibited transaction rules for IRAs, but there really hasn't been substantial enforcement of those rules to date. That likely will change as a result of the way that the BIC exemption is crafted and effectively engrafts an ERISA standard of care onto IRAs, and we'll discuss that. The BIC exemption itself, when it was proposed in 2015, had some issues. It had some challenges. As many of you know, there were multiple written comments to the Labor Department, many of which focused on the various provisions of the BIC exemption. There were a lot of provisions in that proposal that were frankly very onerous. The department has made some changes to the exemption, and we'll talk about sort of the before and after. The heart of the exemption remains, however, and so there are likely going to be challenges in complying with the BIC exemption as we go forward. And importantly, the BIC exemption does retain the concept of an impartial conduct standard, and we'll talk about that as we go, and the impact that that has on providers that are seeking to earn differential compensation or compensation that varies according to the type of investment that they recommend. That has some real challenges to it. There are a number of questions that one needs to think about in analyzing the new proposal. It's important to remember that the regulation only applies to fiduciary investment advice. And so the logical question to ask when analyzing a transaction or a scenario is the investment advice being provided fiduciary in nature? And so there are a handful of questions to think about. Is there a recommendation? There needs to be a recommendation in order for there to be covered investment advice. It's also important to think about the mode of delivery of the recommendation. Is it being made orally? Is it being made in writing? Is it being made on a narrow scale to an individual participant or small group of recipients? Or is it being widely disseminated through some sort of a general publication or a prospectus? All of these things become very important. Is the recipient of the recommendation covered under the regulation? We'll talk about what that means. Very important, is there a fee? The regulation and the statute are very clear that it has to be investment advice provided in exchange for a fee, direct or indirect. So there needs to be some sort of a fee in the mix. That can be challenging to think about where the fees are coming from, because the concept we think is very broad. But again, that's an important thing to keep in mind, the presence of a fee. And then finally, is there an exception? It may be the case that the entity or the person providing the advice is, by all accounts, a fiduciary, meets the definition, but as we will discuss, the department has created several safe harbors in the regulation itself that provide some relief depending on the type of provider that you are and depending on whether you fit within the box that applies to those exceptions, and we'll talk about those. So on slide 10 here, this is a chart that I think is sort of helpful for thinking about whether you've got fiduciary investment advice. And the important concept is underlined at the top, and it is the fact that someone is providing investment advice on a fiduciary basis, if he or she makes a recommendation to certain recipients, again, for a fee, and there's either an acknowledgement by that person that that person is indeed a fiduciary, or the arrangement has certain other attributes that make that a covered recommendation, again, unless there's an exception to that fiduciary status. And you see on the left side of this diagram, these are the types of recommendations that will put one into the fiduciary universe. And they're fairly clear, and they're fairly consistent with the proposal. One, of course, would be a recommendation as to actually acquiring or holding or disposing of certain types of investments or investment property. Another would be, and this is key to this whole package, it's really something important to keep in mind, a recommendation as to a rollover, how property should be invested after a rollover, whether there should be a rollover at all or a distribution. Again, remember that the Labor Department is really zeroing in on the IRA rollover space, so very important to keep in mind. And then a handful of other types of recommendations that really go to how investments are managed. So making a recommendation regarding investment policies, or how to design a portfolio, or very important recommendations as to who to hire to manage one's investment portfolio, and several others. These are all recommendations now under the Labor Department's new regulation. But it's not enough, of course, that there is a recommendation. It has to be to a certain person or a certain type of entity. And so here we move to the center of the diagram, and the recipient, for purposes of this analysis, needs to be one of these types of entities or individuals: a plan, which would be typically an ERISA plan, the fiduciary of that plan, so perhaps the investment committee or the named fiduciary or the plan sponsor, an individual plan participant or beneficiary, and very often this will be a 401k plan participant, a self-directed plan, for example, an IRA, an individual retirement account, of course, or the owner of the IRA, the individual that owns that account. All of those individuals are covered recipients for purposes of this package. And then, of course, as we discussed, there needs to be some type of fee or other compensation. Doesn't necessarily have to be direct, could be indirect, and there are a lot of ways to satisfy that. And then finally, the third piece of the arrangement is, in order to really satisfy this being a fiduciary recommendation, the person giving the advice either has to acknowledge that it's acting as a fiduciary, but even if it doesn't, even if the person doesn't say, I am a fiduciary, there are still other ways to fall into that tent. One would be, of course, directing advice to specific recipients regarding the advisability of a particular investment management decision, or securities or other property, or that the advice is given under an arrangement or an understanding that it's based upon a recipient's particular investment advice needs. So you can see from the diagram here, if you compare this to where we've been to the current approach that the Labor Department applies to analyzing investment fiduciary status, you can see that this is much broader. That some of the high hurdles for meeting this standard have fallen away, and there are many possible avenues to finding oneself acting in a fiduciary role when giving investment advice. So care is really the order of the day here. In terms of slide 11, this just gives you sort of a side-by-side look at certain things that perhaps either are likely to be covered recommendations, i.e. recommendations that will put the advice giver into fiduciary status, or things that are not. It's an objective, not a subjective test, so it doesn't really matter what the person thought if it meets those objective criteria. The more tailored communication is, the more narrowly focused it is, the more likely it is to be a recommendation. The Labor Department is very clear in noting in the preamble to the regulation that making a recommendation with regard to a narrow or a select list of securities as appropriate for the recipient is going to be a covered recommendation. And even individual recommendations taken alone, they may not be covered recommendations, but pulled together, added up in the aggregate, all of that could in combined fashion lead one to a fiduciary recommendation. There are still, however, some areas where providers can take actions that will not result in fiduciary status. The provision of investment platforms to participant-directed ERISA plans, 401k plans, for example, those are going to remain non-fiduciary activities under certain circumstances. Providing selection and monitoring services regarding investment lineups for 401k plans. Those likely remain non-fiduciary again if certain conditions are satisfied. The regulation also provides a carve-out or a safe harbor for general communications. So communications that are not targeted to a particular individual or recipient, but rather made on a broad scale, publications, prospectuses, newsletters, that sort of thing. Those likely will be not fiduciary in nature. And then a popular carve-out, and it has been for a while, the investment education regime. This, of course, has previously been codified in a particular investment bulletin by the Labor Department, IB 96-1. Some of you may be familiar with that. That has now been essentially replaced, superseded by the regulation itself. The regulation closely tracks the old IB 96-1, makes several changes, but it largely mirrors the existing investment bulletin. There are a couple of other carve-outs that I think are helpful to discuss. One of these is what's being referred to as the independent fiduciary exception, and some of you may have come across this in reviewing the new package. The department recognizes that by virtue of the expanded definition of fiduciary, many more service providers are going to be deemed to be ERISA fiduciaries or IRA fiduciaries, and so that will expand the prohibited transaction exposure for those folks. And so the department has helpfully included in this package an exception for independent fiduciaries, and by this I mean for advice that is provided to plans or to IRAs that are represented by an independent fiduciary. The theory being that if there is an intermediary, if there is somebody between the plan and the advice provider, somebody that can reasonably evaluate the advice on behalf of the plan, the IRA owner, the plan participant, then the advice giver in that scenario should not be deemed a fiduciary. And so there are several different types of entities that would satisfy that independent fiduciary definition. So-called professional fiduciaries like banks, insurance companies, registered investment advisors, broker-dealers, or fiduciaries that have custody of plan assets totaling at least $50 million. So fiduciaries of large plans, for example, if they are effectively in between the advice provider and the advice recipient, that would essentially cut off fiduciary status on the part of the advice provider. There are also carve-outs for swap transactions. for advice provided by employees of a plan sponsor. So if a plan sponsor has an in-house investment staff that's providing advice internally to the employer, there's a carve-out for that. But of course, as with all things in this area of the law, there are numerous conditions that apply to each of these types of exceptions, and so it's important to take great care. If you're relying on one of these exceptions, you really need to parse the language in the regulation carefully. And I would also suggest that it's helpful to look at the preamble. A lot of the sort of questions that we get, that we grapple with, find some resolution in the language of the preamble itself. So I commend that to you. There are some other issues that are interesting to think about. I mentioned before that one way of being a fiduciary is to recommend someone else to manage a plan's investment portfolio. Helpfully, the Department of Labor specifies in the new regulation that recommending oneself as that investment advice provider or investment manager is not going to be fiduciary advice in nature, and that was in response to concerns that certain folks in the financial services community had in the proposal stage, where they said, well, if we recommend ourselves, that's fiduciary. You know, how does that work? It really doesn't, and so the department has clarified in the new package that merely recommending oneself as an asset manager, for example, is not typically going to be fiduciary, but it's limited, and there are real challenges, such as where the provider recommends himself, but then recommends a particular investment product along with that. That gets problematic, and so there are challenges with that. Obviously, we've talked at some length already about rollovers. They are absolutely in the crosshairs of this package. They are really front and center in the various components of this, and so an important thing to keep in mind. The platform provider exception we talked about a few minutes ago, that has some limits that may be challenging, and there's also this sort of interesting dynamic between the independent fiduciary exception, or as some folks call it, the seller's exception that we talked about a moment or two ago, where there's an independent fiduciary in between the provider and the plan, and the BIC exemption. And essentially, if you fall within the definition of the seller's exception, you can rely on that. You can't rely on the BIC exemption because the requirements effectively mirror each other. The theory being that if you can satisfy the seller's exception, you don't really need the BIC exemption because you're not a fiduciary at that point. So you don't have a fiduciary conflict for which you need a class exemption for prohibited transaction relief. Why don't we pivot now to the BIC exemption, because a lot of folks are grappling with this, and this is going to be a substantial part of this package. You know, I should say up front that there have been some changes to the BIC exemption vis-a-vis the proposed version, the 2015 version. And when we gathered earlier this year in February, we chatted through some of the difficulties in complying with the proposed BIC exemption. And to be sure, some of those are still there. There are many challenges that are going to go along with complying with the final BIC exemption. But to be fair, there have been a handful of changes that we think will make compliance with the exemption at least easier. Not easy probably, but easier. One of the things that's important to note is the department in the final BIC exemption fixed a gap in the way that the proposal was written. That there was this interesting nuance in the proposal that plan fiduciaries were typically not subject to the BIC exemption. Only advice to plan participants was covered, and so that left sort of uncovered or unrelieved certain types of advice to plan fiduciaries. The department has fixed that in the final version of the exemption, and has made clear that the BIC covers advice to both plan level and participant and IRA holder advice. The contract requirements are easier to deal with now, and we'll talk about that in a moment. But essentially, the contract requirement for ERISA plans has gone away. So for providers looking to rely on the BIC exemption for their advice to ERISA plans, they no longer will need a separate contract in order to rely on that exemption. The contract requirement remains for IRAs, however. You may remember that the proposed BIC exemption had a number of very challenging information technology related disclosures, upfront disclosures, ongoing disclosures, periodic disclosures. Those have not necessarily gone away, but some of them have been omitted and some of them have been streamlined. And so versus the proposal, there are now fewer intrusive disclosures that providers have to grapple with. But very important, what was true of the proposal remains true of the final version of this exemption, which is the best interest standard of conduct. This is really emblematic of the Labor Department's effort to engraft an ERISA standard of care onto IRAs. Remember that IRAs and IRA rollovers are really a key focus of this regulatory initiative. But as we've discussed, IRAs are not subject to ERISA, and so heretofore, providers to IRAs have not had to comply with the same standard of care, the duty of prudence, the duty of loyalty that applies to ERISA plans. But as we're going to discuss, one of the conditions for receiving exemptive relief under the BIC exemption is adherence to an ERISA-like standard of care, which is under the best interest contract exemption, referred to as the best interest standard of conduct. It's very important that if you're looking to rely on the BIC exemption, you typically will now have to acknowledge your fiduciary status. This is very important at the Labor Department. The DOL made a point of saying that you can't have it both ways. You can't say you're not a fiduciary, but then also get the relief afforded under the BIC exemption. One must acknowledge fiduciary status in order to get the benefits of the BIC exemption. And there is the impartial conduct standards. Again, we talked a moment ago about the concept of prudence and loyalty. That's something that providers to ERISA plans are already well acquainted with. ERISA 404, Section 404, of course, imposes upon fiduciaries a duty of prudence, a duty of loyalty. As a condition of relief under the BIC exemption, the department has said that providers to IRAs also have to adhere to those standards. So that's a substantial change from where we've been. Another part of the impartial conduct standards is the concept of reasonable compensation. And again, this is something that's probably familiar to you from your work in the ERISA space, where ERISA has very clear requirements about the payment of fees and compensation in exchange for services. That sort of compensation typically has to be reasonable, and there's a statutory provision and a regulation that governs that. It's Section 408 of ERISA. The reasonable compensation standard also now applies to reliance on the BIC exemption. The department did helpfully clarify in the new BIC exemption that reasonable compensation for purposes of the BIC exemption is largely coextensive with what we understood it to mean for purposes of ERISA and Section 408 of ERISA. So that is helpful. And then finally, the third sort of leg of the three-legged stool, that is the impartial conduct standards, is that there be no materially misleading statements. So if you are a provider and you're relying on the BIC exemption, the advice that you give to the recipient and the disclosures that you make to the recipient about your fees, about your conflicts, about your business, they should not contain materially misleading statements. A failure to satisfy any or all of these pieces of the impartial conduct standards undermines the ability to rely on the exemptions. So it's very important to get these right. Of course, if that weren't enough, there's more. There are a set of warranties that go along with relying on the BIC exemption. Essentially, warranties that providers have to extend to recipients, to the retail investor receiving the advice. Adoption of policies and procedures by the advice provider that they will manage and mitigate conflicts of interest. Recall, of course, that this entire regulatory package is aimed at eliminating or at least mitigating conflicts of interest that the department thinks result in a net financial loss to retail investors. So no surprise that that's at the heart of this exemption. The identification of material conflicts on the part of the service provider and the identification of a specifically named BIC compliance officer, not dissimilar from a chief compliance officer or any other sort of named officer in a corporate structure. These warranties are also very clear that the use of quotas or appraisals is typically forbidden, except where the use of those things is intended to keep everyone's interests aligned, the providers and the recipients. In addition to the warranties, there's a set of written disclosures that have to be provided by the provider to the advice recipient. They have to be in writing, and they typically have to be done at the time of or prior to the execution for which the exemption is needed. So the transaction that gives rise to the prohibited conflict, the disclosures have to be made before the time of that transaction. There is a window for curing errors that are made in good faith, a 30-day window. So that is helpful. Very important, there are certain things that cannot be included in the contract that gives rise to reliance on the BIC exemption. Just as there are certain things that have to be required, there are certain things that are forbidden to be required, or to be included, rather. Disclaimers or limitations on a financial institution's or advisor's liability, that's not permissible. Also very important that the Labor Department was clear that qualifying or limiting or waiving an investor's right to participate in class actions is forbidden, as is requiring mediation of claims in unreasonable or distant venues. Keep in mind here that a key piece of this exemption is to give IRA owners a direct contractual claim against financial services providers. As we've discussed a couple of times now, IRAs are not subject to ERISA, so IRA owners don't have the Labor Department as their proxy, as their advocate. The Labor Department doesn't have any jurisdiction in this space. So one way that the Labor Department has tried to address that or fix that is by virtue of requiring this written agreement with IRA owners. The agreement opens the door to litigation, direct litigation by IRA owners against financial services providers. And so it would make sense that the department would not allow the contracts that govern those relationships to limit or waive procedural rights regarding how those IRA owners seek to institute those actions. There are things that are permissible, however, requiring mandatory arbitration for non-class actions, so non-collective actions. That's permitted, as are limitations on punitive damages or the right of rescission. There are a number of disclosures that go along with the BIC. We've identified those here on slide 18. Won't go through all of them except to note that, again, the department has tried to streamline and reduce some of the disclosure burden on providers in the final BIC exemption. One of the differences in the BIC exemption that is final versus the proposal is that there are now effectively 3 versions of the BIC exemption, and I think this is a meaningful change and may well prove to be a helpful one. And basically, we think of these as 3 different pathways to the same type of relief, to the BIC relief. And the first pathway is really the version that applies when an IRA owner is on the other end of the advice or the transaction. In the case of an IRA owner, again, the IRA gets pride of place in terms of this regulatory regime, and so all of the various requirements are going to apply in the case of advice to an IRA or an IRA owner, meaning that there has to be that full bilateral contract that I mentioned a few minutes ago between the provider and the IRA investor. All of the contents that we discussed have to be included: the fiduciary acknowledgement, the impartial conduct standards, the warranties, the disclosures, and of course the absence or the omission of those ineligible provisions that we talked about. In terms of the process, there has to be, the agreements need to be signed up for new accounts, but the department did make clear in the final regulation, in the final exemption, that for existing contracts, negative consent would be permitted to apply the BIC exemption to those contracts that were entered into before January 1, 2018. So that was a change. This means that folks looking to rely on the BIC exemption for IRAs don't necessarily have to go back and repaper all of those arrangements, which in the case of IRAs could be very burdensome. The second pathway is really the pathway that applies to the use of the BIC exemption in the case of ERISA plans. And here the department has taken off some of the trappings that apply to IRAs. Most important, there's no bilateral contract. So for ERISA plans, unlike IRA providers, financial services firms don't have to go out and sign a separate contract with ERISA plans. And the reason for this, as DOL explains in the preamble, is the department already has plenary authority over ERISA plans. That's by virtue of the statute itself, by ERISA. The department has jurisdiction and authority over ERISA plans, so it can step in and file suit at any time, as can participants in certain cases. So you don't really need that added contractual right to relief because it's already right there in the text of the ERISA statute. And this is a deviation from the proposal where a contract would have been required for both IRAs and ERISA plans. So we think folks are probably happy with that outcome. And then finally, there is this third pathway that you may have heard about, which we've taken to calling BIC Lite, L-I-T-E, meaning a purportedly lighter, less heavy version of the full BIC exemption. And this really applies to situations where there may be a conflict, there may be a need to rely on the BIC exemption because the transaction in question would involve a prohibited conflict under ERISA or under the code, but the conflict is less egregious, is more narrowly confined. For example, an IRA rollover, a plan to an IRA rollover. There may be a conflict there because the advice provider stands to earn a fee by virtue of setting up the IRA that it would not have if the plan had not rolled the money over to an IRA. But very often the ongoing fee is a simple assets under management sort of fee where the fee itself is simply tied to the value of the assets in the portfolio and really doesn't have a lot of conflict concerns associated with it. For those types of arrangements, the department has said that providers have access to a lighter version of the BIC exemption, which means that there's no written contract, there's no disclosure that's required. There are, however, the requirements of the fiduciary acknowledgement as well as the impartial conduct standards. So the heart of the BIC exemption, the full BIC exemption, still applies to the BIC light. Very important. It's important to note that in recommending one of these types of rollovers, the provider still has to document why moving from a commission-based account to a level fee arrangement, meaning an arrangement where the fees are simply tied to the value of the assets in the account, why that's in the investor's best interest. I think we had a question from the audience before the presentation that asked about how the new regulation applies to existing versus new IRAs and whether there are any particular nuances that apply to providers, for example, banks or trust companies that only earn an asset-based fee. And this BIC light concept may well apply to those types of providers where they may be in the business of rolling over plan money into IRAs, newly created IRAs, and there may indeed be a conflict in doing that because, again, as I said, of the ability to earn an ongoing fee. But if the conflict is limited in that situation, and the ongoing fee is really an asset-based fee, a percentage of the assets under management based on the value of those assets, providers in that space may be able to take advantage of the BIC light regime. It's important to note that there is some question about whether any indirect compensation is going to be permitted under this BIC light concept. The department is pretty clear in the text of the exemption in defining what a level fee is, and so we're still grappling with how one deals with things like soft dollars or other types of third-party payments, and whether in the presence of those types of payments one can conclude that the fee is indeed level. So it's important to think about those issues carefully if you're relying on this pathway. There is and there was a concern during the proposal phase of the package about proprietary products. There are some providers that only provide proprietary products, meaning funds or products issued or manufactured or produced by those providers. And the department has made clear in the final BIC exemption that proprietary products are allowed. They can be part of the provider's investment advice offering, but there are conditions that go along with that, including written disclosures, the disclosure of material conflicts that go along with only providing proprietary products. There needs to be a prudence conclusion that providing proprietary products, recommending proprietary products, won't cause the recommendations to become imprudent. The compensation, of course, still has to be reasonable, and that the recommendation itself is not based on the advisor's own financial interests, but rather those of the investor, of the recipient, which makes sense given the department's overall goals with this regime. We will turn to talking briefly about some of the individual changes to the existing exemptions. I mentioned at the beginning that we've expanded the definition of fiduciary. We've expanded the universe of fiduciaries. In doing that, the department has created some safe harbors. It's also created this brand new prohibited transaction exemption called the best interest contract exemption. But in addition to that, the department has made some surgical changes, discrete changes to a handful of existing exemptions, class exemptions that providers typically rely on. And one of those is PTE 8424, and a number of you may be well acquainted with 8424. It has been historically the key exemption that insurance providers and insurance producers have relied on as a way of selling their products, marketing their products, but receiving compensation, often commission-based compensation, in exchange for doing that. Well, the department has made substantial changes to PTE 8424 as a result of this new regulatory initiative. And perhaps the most important in this is that that exemption no longer covers variable or index products for plans or IRAs. 8424 used to cover variable or fixed index products. And so now those products have gone away. If you're in the business of providing advice involving those products, you really now have to be looking to the BIC exemption for exemptive relief, which is a substantial change for those in the insurance community. And then the exemption itself has now been substantially narrowed, including in the rollover context. It's really now only available for fixed rate annuity contracts and true insurance contracts. And so the scope of the relief provided under 8424 is much narrower than it was. Also, the concept of a mutual fund commission has been narrowly defined as well for plans. Really, what we're talking about now is really a traditional type of sales commission, essentially a front-end load. So things like revenue sharing and 12B1 fees that were common in this industry now no longer work under 8424. And so, you know, what this is showing us is that the department is really trying to funnel providers into the BIC exemption, which has more robust and rigorous requirements associated with it, and it makes PT 8424 probably a less helpful, less desirable pathway to exemptive relief. The reasonable compensation standard that we talked about in terms of the BIC exemption now applies to 8424, and of course the impartial conduct standards, essentially the ERISA-like standard of care, the no misleading statements, that applies in this context as well. I talked at the outset that in addition to the BIC exemption, there is a new class exemption for principal transactions, meaning transactions that are for the investment advice provider's own inventory. So a broker or dealer sells securities out of its own inventory to a plan or buys things for its inventory from a plan. There's now an exemption that covers those types of transactions, which we describe here on slides 26 and 27 and 28. Because we're running out of time, I will not go through those in detail, but if you're working in this area, that's an exemption that you may find useful to you, and I would encourage you to take a closer look at that. PT 86128, some of you may know, this is typically used in the case of investment advice providers that have affiliated brokers where there may be commissions or revenue sharing. A lot of changes have been made to PTE 86128, and again, so if you're working in this space where you may have traditionally needed to rely on that exemption, a lot has changed now, and so I would recommend that you spend some time with that and with the new language. PTE 75-1, also an historically important class exemption, has seen a lot of changes to it as well, a lot of surgical changes. We identify some of those here on these slides. And so again, if you or someone you're working with has typically relied on those types of that exemption, then that's something that you want to be aware of. And finally, there is a series of existing class exemptions onto which the department has engrafted the impartial conduct standards that we talked about in the context of the BIC exemption. that set of standards now applies to a series of prohibited transaction exemptions that are heavily relied on in the financial services community, including the very commonly relied on PTE 77-4, which applies to the use of affiliated mutual funds. I do want to very quickly mention the litigation that has appeared on the scene over the last month or so. Many of you are probably aware that as of today, 5 lawsuits have been filed against the Department of Labor and the Labor Secretary, Tom Perez, making various but relatively consistent challenges to the regulatory package that the department has set forth here. These lawsuits really raise constitutional challenges and various other federal claims attacking the grounds for promulgating the regulation. 3 of those are in the Northern District of Texas. 1 of them is in D.C., and then 1 of them is in Kansas. There is a motion currently pending to consolidate the 3 Texas cases before a single court for administrative flexibility, and there is a proposed briefing schedule for that. Also, in 1 or 2 of the cases, motions for preliminary injunction have been filed, which likely will put those cases on a fast track. So there's more to come. It's early days, unclear yet whether the plaintiffs in these lawsuits will get any traction on their claims, but we are likely to see a flurry of activity in many of these cases as we go into the summer and into the fall as well. The 5 cases are identified here on slide 35. They do make for interesting reading, and some of them really do a nice job sort of tracking through the history of the development of the regulatory regime in the employee benefits space. So it's educational in terms of sort of learning about where we've been as a view to where we're going. I see that we have just a couple of minutes left, so I think it's a good time to wrap it up. I'll turn it back to Mike for any concluding comments or questions.
Thanks. That was awesome. I appreciate the thoroughness of the review. There's a couple of questions. One I'm going to shoot to you afterwards in an email so you can follow up because it's specific. But here's one. Actually, there may be a couple, but here's one that is in general, which is how will the Department of Labor enforce this rule? How do they go about enforcing something like this?
That's a great question. I think that there are several answers to that. The Department of Labor itself really only has enforcement authority over ERISA plans by virtue of the statutory authority given to the Labor Department. And so what the Labor Department has really done is in effect say, we don't have the ability to enforce everything that needs to be enforced. So by virtue of creating this best interest contract exemption, we're going to create an enforcement mechanism for the individual IRA owners. And so I think what we're really looking at here is kind of a dual enforcement mechanism where the Labor Department will have regulatory and enforcement authority as to ERISA plans and will rely on the plaintiff's bar largely to enforce the requirements as to IRAs.
Okay, great. Now, you mentioned these lawsuits. I mean, I'm assuming that for your clients, for people you're speaking to, I mean, everybody is moving ahead, assuming that this becomes law, because there's so many things that have to be done to put their processes in place, right? I mean, are most people moving ahead as if this will become law?
I think so.
They will not be stopped?
Yeah, I think, the sense we're getting is that most of our clients are resigned to the fact that at least for now and probably for the foreseeable future, this is a real issue, and so the time is going to go quickly, and we're going to be at the effective date before we know it, and there's a lot to do, and I think people are moving forward with reviewing their models, reviewing their processes, looking at their form agreements, doing the sorts of things that they think that they will need to do to be in a position to comply on day one.
Okay, that's kind of what I thought. We're right at the top of the hour, and Alex, I'm going to shoot you a couple of emails when we're done that are on kind of specific questions, and you can reach out to those people. I appreciate everybody taking the time today. I certainly appreciate Alex Ryan and his insight today on this important issue. As I mentioned for everyone, have a great summer, and check back around the middle of August for the sessions we have lined up for the fall. And Alex, again, thank you very much, and thanks everyone for attending today. Thank you very much.